Well, while we're waiting, I'm going to ask counsel for the appellee a pronunciation question. Is it Caballero? The double L being a Y in Spanish?
If I'm visiting Miami, Judge, but it's Cavallaro, close.
Okay. All right.
I
So you're not.
apologize, Your Honor. I didn't get the pop-up until after she asked about that.
Don't worry, not to worry. We're not going anywhere. And I want to make sure I got a pronunciation right. So I figured we could keep everything moving. Attorney Hapner, did you wish to reserve any time as appellant's counsel for rebuttal?
Yes, Your Honor, 5 minutes, please.
Okay. I have noted that, and I will do my utmost to be timely to let you know that you have arrived at that particular point of your presentation. With that being said, we are ready to begin, counsel.
Thank you. May it please the court, counsel. I would first like to address the issue of the statute of limitations because it's our position that even if there was a breach of contract, which we dispute, that the action in this instance was not timely. So the main purpose of a statute of limitations is to ensure that lawsuits are dealt with in a timely fashion. And this is in order to protect potential defendants from the unfair situation of having to defend something after a significant passage of time. If someone desires to file a lawsuit against another, they should pursue it sooner rather than later with reasonable diligence. Relevant evidence can be lost, memories can fade, things could be obscured. A lot of data these days is not retrievable years after the fact. I think it's important for the court to bear that purpose in mind in considering this case today. There was a count for alleged breach of contract by Integrity Title Group LLC, a now defunct company of which Ms. Lecker was a principal. And there's a second count for indemnity with respect to that contract. So as to breach of contract, the triggering event for the commencement of the statute of limitations is when the last element constituting the breach occurred, pursuant to Florida Statute 95.031 subsection 1. The elements, of course, for a breach of contract are first, the existence of a contract, second, a breach, and third, damages resulting from that breach. But Florida has long followed the general rule that a cause of action for breach of contract accrues at the time of the breach.
Is that true? Is that true for indemnity contracts?
I'm going to address that separately.
Well, you just gave us a blanket principle of law. So does it apply to indemnity contracts?
I don't believe it applies to indemnity contracts per se, but when your indemnity is based on the breach, I think there's a statute of limitations that then applies to the indemnity as well.
But Fidelity is seeking to enforce its rights for indemnification, correct?
Correct.
And the statute of limitations for indemnification does not begin to run until the amount is determined either through a lawsuit or through a settlement or voluntary payment, correct?
Well, because this contract was terminated way back in 2010, it's our position that it doesn't run indefinitely.
Well, you're saying there's no indemnification agreement, but to the extent there is an indemnification agreement and it is enforceable, the statute of limitations has not expired, has it?
As of the date that this litigation was commenced, no, not under those circumstances.
I just want to make sure we're talking about the same thing, Ms. Hapner.
So as to the breach itself, it doesn't run from the time that the consequential damages are ascertained. So it's our position that the statute of limitations on the breach of contract would have run starting February 7th of 2008, when it's alleged that the closing did not properly take place. Then on April 23rd, 2012, NationStar, the buyer, sued the appellee, saying that there was a breach. They settled on July 24th, 2014. The first action was brought by Fidelity on June 3rd of 2016, which unquestionably would have been within the statute of limitations from the Nation Star claim and the knowledge thereof. But for reasons that I am not privy to, obviously, they allowed that case to be dismissed for lack of prosecution in 2018, which was nearly 4 years after the settlement between Nation Star and the appellee, and then brought this second action the end of January of 2019.
Ms.
So-
Haffner, can you help me with one aspect of your argument about accrual? And I think I get the gist of it from the brief, but in addition to the nature of the action that's at issue here, which is a indemnity or monetary guarantee, this is arising in the context of title insurance, and specifically this agent agreement who is authorized to issue title insurance. Under most title policies, and I think it's in this one, I don't know if the title policy was submitted in the record, but I can't imagine it would be different than how they're typically set up, which is when you have a title claim that arises, like we have here, where the mortgage didn't get satisfied during the closing, the title company actually has 3 different things it could do with that claim. It could pay money on it, it could initiate litigation on it, or it could go out and try to settle it. And unless and until the title company actually paid out money on the claim, and it's the title insurer's election whether or not to, how it wants to proceed on that, unless and until it actually pays out that money, there is no breach conceptually, right? At least for purposes of the guarantee or the indemnification. See, I can't see how there would be, because until they do that, they could still clear this claim, either by filing a lawsuit to force, I forget the name of the entity, to force them to issue the satisfaction, or to just call them up and try to work it out with them. But for whatever reason, they didn't do that.
All right. Instead, litigation was commenced back on April 23rd of 2012. So, again, it's our position that the last date that the statute of limitations could commence running on the breach of contract claim would have been April 23rd, 2012. Going on to the issue for the moment, based on your questions of whether or not there was in fact a breach. First, appellee asserts on page 15 of its brief that there is no dispute as to whether a breach of contract occurred. We definitely disagree with that. And then on page 16, they assert that raising the statute of limitations as an affirmative defense is an admission that the contract was breached, which we also disagree with. All of that was basically the entire basis of the appellate's motion for rehearing filed in the trial court. So going on specifically to whether Integrity Title, the former LLC in which Ms. Lecter was a principal, in fact breached the contract as found by the trial court in its summary judgment order. We don't believe that's in fact the case. As Judge Lucas mentioned, there are different options, but there are statutory options as well. Each estoppel letter, there were 2 mortgages, both payable to someone named Shaw, but different Shaws. There was J. Shaw and there was C. Shaw, as they were generally referred to. J. Shaw passed away during the pendency of all of this. So each estoppel letter reflected the mortgagee as the sender of that estoppel letter. And C. Shaw, which would be Cheaton Shaw, the president of UUUU Incorporated, as well as the principal of Rest Assured Title Services, LLC, was deposed in his deposition as part of the record. He acknowledged that he received the funds in question to pay off that mortgage. He also testified that he was acting on behalf of J. Shaw, the principal of JK Trading Incorporated, which was the first mortgagee, and that the funds that were paid to Cheaton Shaw on behalf of J. Shaw for the payoff of that first mortgage were agreed between Cheaton Shaw and J. Shaw to be invested in another project that Rest Assured Title was in charge of, and that therefore the funds were being properly applied. So it appears that all they really had to do was go get a satisfaction of the mortgage and not pay out any damages, much less $150,000. But with respect to the estoppel letters, Florida statute 701.04 subsection 1, subsection B, subsection 3 provides the mortgagee or servicer of the mortgagee acting in accordance with a request in substantial compliance with this paragraph is expressly discharged from any obligation or liability to any person on account of the release of the requested information other than the obligation to comply with the terms of the estoppel letter. Well, the title company fully complied with the terms of the estoppel letter. The title agent, Ms. Lecter, had no idea that there was any type of potential fraud involved in what she got in terms of the estoppel letter. She even telephoned to confirm. So she specifically complied, again, with those written instructions. So she should be expressly discharged from liability. And if she and the title company are expressly discharged from liability, then obviously the underwriter, appellee, is as well. Appellee never asserted that defense or contacted the principals of the mortgages in question to try and get any satisfaction of the mortgage. If so, there likely would have been no payment whatsoever again.
Ms. Habner, just a quick question about that argument.
Mhm.
See the statute you're relying upon, and even assuming it applies here, given the date that it became effective, it seems to me it says it's referring to the mortgagee or servicer of the mortgagee who gets discharged from obligation. Are you arguing that an issuing title agent is what, a servicer of a mortgagee, I guess?
Well, the title agent is acting in the stead of the mortgagee as the person who receives the mortgagee's instructions.
But that doesn't make the title agent a servicer. I mean, that's kind of an understood
Non-mortgage
term.
servicer, no, but an agent.
Right. Maybe an agent. I'm not sure a servicer though. At least
No.
at least as I understand that term.
It's the obligation of the party who receives the funds to pay off the mortgage to generate and supply the satisfaction of the mortgage under Florida statute 701.041 subsection 2. And it also provides for the execution and recording of a certificate of release that can cure the title issue without payment of the claim. Pursuant to that statute, whenever the amount of money due on any mortgage, lien, or judgment has been fully paid to the person or party entitled to the payment thereof, which according to Mr. Shaw's deposition is the case here, the mortgagee, creditor, or assignee, or the attorney of record in the case of a judgment to whom the payment was made, shall execute in writing an instrument acknowledging satisfaction of the mortgage, lien, or judgment, and have the instrument acknowledged or proven and duly entered in the official records of the proper county. Within 60 days after the date of receipt of the full payment of the mortgage, lien, or judgment, the person required to acknowledge satisfaction of the mortgage, lien, or judgment shall send or cause to be sent the recorded satisfaction to the person who has made the full payment. So it puts the onus on the mortgagee to take care of that. There's also a current provision based on this problem occurring numerous times in the past under 701.041 for a certificate of release. That did not exist at the time of this transaction, but it does now as a result of these continuing issues. My client was not notified of or made a party to this 2012 litigation, knew nothing about it until she was sued in 2016 in this initial lawsuit by the appellee. So she had no opportunity to defend, no opportunity to remedy the situation whatsoever. It was purely Fidelity's obligation and opportunity as the underwriter and the defendant in that 2012 12 litigation to be able to cure the situation short of rendering this $150,000 payment, which really unjustly enriched that mortgagee ultimately because funds were paid twice. We also take the position that the lawsuit that was filed on June 3rd of 2016 was a tacit acknowledgement that the statute of limitations was already long since running. And that would have been filed and was filed within the statute of limitations.
And Ms. Hapner, just one question. One of the defenses was latches. You have not raised that as an issue on appeal, correct?
That's correct.
Thank you.
You are almost at 15 at this moment.
I'm done for now. Thank you, Your Honor.
Okay, thank you, counsel. Okay, I have cleared the clock. And Attorney Cavallaro, we are ready. How do I do?
Thank you. Perfect. Thank you, Michelle Cavallaro, on behalf of Fidelity National Title Insurance Company, the appellee. And may it please the court and counsel, Ms. Hapner. I think this is a lot simpler of a case than it appears from going through the facts, because I think a lot of the facts that the appellant raised are really inapplicable because they go down this rabbit hole of talking about what happened at the closing and how the funds really, even though they were misappropriated, they could have been clawed back a different way, and perhaps Fidelity could have taken other actions. But that's not, respectfully, that's not what the question is here. The question is, one, did Integrity Title breach their agency agreement contract with Fidelity? And two, was Ms. Lecker personally guaranteeing the performance or losses caused, is a better way to put it, losses caused by Integrity Title's breach of the contract under Schedule D of the contract, which goes, that's the personal guarantee portion of it. So the first thing we look at it in the complaint and in Fidelity's motion for summary judgment is they correctly honed in on paragraph 8 of the contract between, and again, the whole contract, the purpose of it is to talk about the business relationship between not only the title agent, our title agent, and what they're responsible for, what they have to do, what we have to do, what we're responsible for. And then it also talks about Ms. Lecker's personal responsibility if the title agent does not do what it's supposed to do. And in this case, it's undisputed that, and I know I say that, Ms. Hapner just said it was disputed, so I'll talk about that in a second. But I think it's undisputed that the funds here were misapplied. And when closing funds are misapplied, and in this case, the funds were supposed to go to pay off North Star, the lender, didn't do it. Or sorry, the prior lender, my apologies.
North Star's you're insured.
Yes, thank you, Judge Lucas. When North Star's funds were supposed to go to pay off this prior mortgage, in fact, that prior mortgage wasn't paid off. And I know this court's aware, and pretty much everyone in the state of Florida handling real estate transactions is aware that wire fraud and mortgage fraud are fairly rampant right now. So this is not a surprise that, in fact, closing instructions by some nefarious person are tried to be altered, and title agents get these communications sometimes that tell them, you know, don't worry about paying this lender, now pay this guy. And sometimes they fall for it. And that's exactly what we have in this case. The title agent in this case just happened to fall for it, paid the wrong party. Now, I know the appellant doesn't like the fact that Fidelity didn't go after that wrong party. We don't have too much in the record as to that. We just know that the initial lawsuit, I think in 2012, ended in a dismissal, a voluntary dismissal. That's pretty much all we know. And we don't really know what happened, the rest of it. But what we do know is the funds were misapplied by this agent. And we don't have to look further than that under the contract, because paragraph 8, E is in Edward, subsection 1 says that Integrity must be responsible and is liable for the misapplication of funds. And this is the crucial part, I think, resulting in a loss to Fidelity. So when we talk about when the breach occurred and we talk about when the statute of limitations started to run, we can't talk about that without looking at what provision was actually breached. And this contract, specifically paragraph 8, Integrity Title did not breach that provision until a loss occurred to Fidelity. Now, I think the appellee wants to conflate a loss to its insured versus a loss to Fidelity, and those are totally different things. And I think Judge Lucas touched on this a moment ago, which is that, you know, the title insurer has options, and Fidelity as a title insurer in this case suffered its loss when it chose to pay off the prior lien holder mortgagor that should have been paid off by Integrity Title and wasn't. And that, again, that was their fault, Integrity Title's fault that didn't happen. So Fidelity, when it chose in 2014 to pay that off to the tune of $150,000, that's when the breach occurred of this contract between Integrity Title and Fidelity, because under the plain meaning of the words in that contract provision, it has to result in a loss to Fidelity, not to the insured. And I think that's a very important distinction to make here. Yes, the insured may have suffered the loss before that, but Fidelity didn't suffer the loss until it paid the $150,000 to satisfy the mortgage that should have been satisfied by Integrity at the closing. So what does this mean for Ms. Lecker? It means that because she personally guaranteed every obligation and every provision in the contract, according to the plain language of Schedule D, that means that she is also responsible to Fidelity and indemnifies Fidelity for any loss. And again, the loss didn't occur until 2014. This lawsuit was filed in 2019, January 2019 to be exact. So by those dates, it is within the statute of limitations. And then if I move on past that, the other point in the brief, which I don't know, maybe I'll stop here and see if there are any questions about statute of limitations before I move on to the second part. So I'll move on. The second part of the initial brief then talks about the personal guarantee and talks about the fact that there's a list. Again, we're honing in on paragraph 8 of the contract, because that's what the obligations that were breached here by Integrity Title. And as I understand the appellant's argument, it's that when there's a list of things that Integrity Title was responsible for making sure happened and that it did properly, everything in that list has to occur before there's personal liability on behalf of Ms. Lecker. That's just not close to an interpretation of the plain meaning of indemnification and of a personal guarantee and of the specific words of this personal guarantee. It doesn't say that. And importantly, the personal guarantee also doesn't accept any of the provisions of the contract between Fidelity and Integrity Title. It says all, and it means all, and there's nothing ambiguous about those terms. I don't even think the appellant argues there's any ambiguity in these contractual provisions we're talking about today, which is another important point, because under our rules in Florida, And in this district of contract interpretation, the plain meaning applies unless there is some patent ambiguity. And there just isn't. And again, I don't even think the appellant argues that there is. As a last point, I think that was made in the initial brief is that the title commitment itself, because it did not contain specific instructions that were breached by Integrity Title, there was no breach of the contract. And so there is no personal liability by Ms. Lecker. So I also am going to take issue with that point because the title commitment does in fact contain specific instructions. And it's part of the record in this case. And it does contain the requirement to obtain a satisfaction and release of that prior mortgage. That's pretty clear. Those are instructions that Fidelity, as the principal, is giving to its agent, Integrity Title, as the grounds to then go ahead and issue its title policy on its behalf to North Star, because this was a lender's title insurance policy. So that had to be met, that condition had to be met by Integrity Title, and it simply wasn't. I think that's very clear from the title commitment itself, that again is part of this record. And I also stated, and I believe this is the case, that was not raised by the appellant in the trial court below in terms of the instructions of the title commitment. But again, even if it were raised and I somehow missed that in the record, again, that's a non-starter. So circling back to my initial thing, I thought of a good hypothetical that sort of, I think, congeals the argument in terms of the statute of limitations and when it runs and when the breach occurs. And that is this. What if Integrity Title had misapplied the funds, as they did, and North Star made its claim to Fidelity, as it did, but Fidelity, in looking at that claim and
Speaker who has frozen, at least on my screen. Anybody else having that issue?
Yeah,
Yeah, she's frozen.
Are you back? It seems.
Jeez, I don't know what happened.
Uh,
Apologies.
That's quite all right. We don't know either. We're just glad to have you back.
Well, that was one heck of a finish.
Well, that's probably good, except, we missed it.
So let me
You
quickly.
may have to reprise it. And the good news was that initially I stopped your time, so we got you back. So we don't have to worry about running out or anything. And you're not even close anyway. You're only at about 11 and a half. So we're good. So
Thank you.
you may want to pick up apart and restart there. I think you were talking about your hypothetical or your example to tie it all
Yes.
together.
Yes, so we take the first two steps that occurred still the same, which is that Integrity Title misapplied the funds, the lender's funds, North Star's. Two, which is still the same, that North Star makes a claim under the policy to Fidelity and says we never received our payoff. But here's the difference. Fidelity then, let's say, investigates the claim, does its due diligence, and finds that, wait a minute, in fact, North Star did receive the payoff. They mistakenly, for whatever reason, either thought they didn't receive the funds, and it turns out they did, which, believe me, if you've ever represented Wells Fargo, does happen with larger banks. So let's say in that hypothetical that happened. In that case, would Fidelity be able to sue Ms. Lecker for either indemnification or breach of contract? Would Fidelity even be able to sue Integrity Title for breach of contract? They wouldn't, because there's no loss. If Fidelity never paid the $150,000, if Fidelity never satisfied that prior mortgage, Integrity Title would not have caused any loss to Fidelity. And that's the triggering event under paragraph 8 of the agency contract. So once the loss occurs, that's what triggers the breach. And so I think I say this in my answer brief, and I'll reiterate it. It's not always true that a breach does not occur at the same time as damages. And I think here the appellant sort of assumes that both of those things can't happen at once. I say they can, and this case is a perfect example of it. In this case, the breach occurred under paragraph 8 of that contract when there was a loss to Fidelity by the exact words used in that contract provision, resulting in a loss, quote unquote. So once that happens, yes, you actually have the breach and the damages happening at the same time. So that is not an oxymoron. That can actually occur. That's what occurred in this case. And I appreciate the court's indulgence. I don't know what happened to my Zoom. Unless there are any questions, I'm going to end there. So
Counsel, I don't see any further questions.
then we would just end by asking that this court affirm the trial court's rulings and uphold the entry of final judgment on behalf of Fidelity in this case.
Thank you. Turn to counsel for the appellant. Attorney Hapner, you have your 5 minutes remaining.
Thank you, Your Honor. Ms. Cavallaro, and excuse me if I mispronounce that, referenced paragraph 8 of the agency agreement a number of times, and I'd like to also. Paragraph 8E subsection 3 talks about misappropriation, which she also referenced misappropriation by the agent several times. It says misappropriation of escrow or closing funds by agent, its officers, subcontractors, or employees. The person responsible for any misappropriation would be the person who perpetrated the fraud, the now deceased Mr. Shaw. It was not the title company, the title agent, or any of its employees.
Indemnification would also be available under subsection 2 of that, failure to disperse properly or close in accordance with escrow and or closing instructions, right?
Right, but with the misappropriation that she was talking about, I wanted to cite to that portion. The guarantee, the personal guarantee, is specifically conditioned on the agency contract. The agency contract was terminated. The parties entered into a mutual termination agreement on November 22nd, 2010. Shortly thereafter, that title company became defunct for unrelated reasons, but it's our position that you can't hold someone responsible under a guarantee that does not specify that is going to continue after termination of the contract indefinitely. So the contract having been terminated in 2010, the closing having taken place in early 2008, it's patently unfair to turn around in 2019 and sue the appellate under this 2008 incident and based on a 2006 personal guarantee. The statute should have started running after the termination of the contract, and therefore there should be no liability after November 22nd, 2015, because there is no agency contract. There was no timely notice. The guarantee should be void at that point as well because of the passage of time after the termination of the contracts. I cited Alonzo Lamares, I'm sure I'm mispronouncing that, versus International Dermatology Research Incorporated. In that case, Dr. Alonzo entered into an employment contract that included a 2-year non-compete and a termination clause that specifically included a provision that stated, and I quote, "All duties and obligations of the physician intended to survive termination shall survive, including physician's obligations under sections 8, 9, 12, and 13 of this agreement, unquote. That's not the case here. There's nothing in this guarantee that says that it survives termination of the contract.
What
So
about paragraph 9B at the end where it says, in the event this contract is terminated, the obligations to make any payments, including without limitation, the agent's liability for loss under paragraph 8 herein to provide notification as to claims and to provide access to records and files shall continue beyond the date of termination.
okay, I got to go back there again because this is very small type, unfortunately, on this contract. So let's see, I got to get the right beginning of that sentence. Okay, it says agent shall promptly make an accounting of and deliver to principal on all unused title.
It's the
insurance
last
forms, et
sentence of
cetera.
paragraph
And
B.
then, yes. Okay. In the event this contract is terminated, the obligation to make any payments, including without limitation, the agent's liability for loss under paragraph 8 herein, to provide notification as to claims and to provide access to records and files shall continue beyond the date of termination. But again, that can't go on forever. You know, this action was filed 11 years after this transaction, which is far more than 2 5-year statute of limitations. There has to be some type of finality in terms of your obligations, which is the whole purpose of a statute of limitations, is not to be put in this situation more than a decade down the line when you've had no prior notice other than a lawsuit in 2016 that they allowed to have voluntarily dismissed or dismissed for lack of prosecution in 2018. So she thought, of course, that she was long since done with this.
Counsel, I need to advise you that we have gone beyond the 5 minutes.
I'm
So
done,
that
Your
was-
Honor. Thank you.
Thank you so much. Thank you both. It's been a pleasure this morning. And that will conclude this oral argument for this case.